Hello, everyone. Thank you for coming to my talk this afternoon on the issue of Japanese knotweed. If there's any problems with people hearing me or the like during my presentation, if you could just let me know in the chat box, and I will stop to solve any issues if they're at my end. So my talk's going to be on, as I said, Japanese knotweed and the latest Supreme Court judgment, which was handed down early last month, I think on the 8th of May, regarding causation and Japanese knotweed. And whilst it is the case and the facts were about Japanese knotweed and its effects on diminution of value, I do think there are some wider drawings that we can take from the particular case. So let's get into it. So there were really two issues that the Supreme Court addressed in its judgment. So first is about but-for factual causation in private nuisance cases. So that's number one. The number two was whether residual diminution of value was recoverable as reasonable cost of abating a continuing nuisance. And that's drawing upon what the Court of Appeal ruled in the earlier hearing on using the case of Delaware from 2001. So these are the two issues that the Supreme Court clarified in this decision. So let's go into a bit of the factual background. So these were the findings of fact that were made by the district judge at the first hearing, and these were not in dispute between the parties when it came to the appeal point. So the first was that the encroachment, and the most important one that I'll be coming back to again and again, is that the Japanese knotweed began to encroach onto the property before 2004. That was a fact that was established. And that's when the roots, the rhizomes, I think they're called, started to seep in from the council's land, which was next to 10 Dinham Street, which was owned by Mr. Davies. And 2004 is the year in which he bought that property. So even before then, when he bought it, the Japanese knotweed was beginning to intrude. Now, between 2004 and 2013, the local authority did not know that the Japanese knotweed was encroaching. It was encroaching in the form of that picture, which I've got there. These are the rhizomes. These are the horizontal roots which get everywhere once Japanese knotweed starts to encroach onto your land. However, that changed in 2013. At that point, the defendant became aware, and they did not do anything to stop the Japanese knotweed encroaching into the property until about 2018, at which point they started to begin a herbicidal treatment of the Japanese knotweed. Now, what that did was to kill the Japanese knotweed on the surface and above ground. But the problem with Japanese knotweed, as some of you may know, is that you have to let Japanese knotweed lie. You can't get rid of the roots underneath the soil. They are there, and if they get disturbed in any way, they can begin to grow again, causing a fresh manifestation of the knotweed above the ground. So it's a continuing problem, potentially, if you disturb the roots. Now, 2020 is when the claimant brought the claim for breach of duty in private nuisance. But I think it's a very important point. There was not a claim for a continuing nuisance. And this is something that I will come back to at the very end of my talk. Now, one of the heads of damage was that it was damages for the residual diminution of value of his land. And that's because these rhizomes, the technical term for these roots, these horizontal roots, are still there present underneath the land of his property. And the problem with Japanese knotweed, as some of you may know, is that mortgage companies and the like often refuse to lend on it. There is also a stigma of having Japanese knotweed on your property and the like. So the £4,900 was for that diminution of value. So the case went to the district judge, and went to the county court, and then eventually up to the Court of Appeal. And the Court of Appeal ruled that there was residual diminution of value was caused by the nuisance of the Japanese knotweed, and that allowed for £4,900 worth of damages to be awarded. So coming to what the Supreme Court did. So the first one's on what I'm going to call the Delaware question. So is that whether the diminution of value can be claimed as part of what's called abating a continuing nuisance. And on this, Lord Stevens was absolutely clear it cannot be. It's its own separate head of claim. And the relevant paragraph for that is paragraph 67. So diminution of value of a property is not recoverable as a form of reasonable cost in abating a continuing nuisance. And in a very, very explicit, Delaware is not authority for the proposition that diminution in market value is recoverable regardless as to whether the diminution occurred prior to the defendant's breach of duty. And that's important because it establishes that there still needs to be a factual causation between the breach of the duty and the loss that's being claimed and whether that is recoverable. So it establishes that the factual causation still exists. That's when we then moved into the but-for test in factual causation. So this is paragraphs 56, 58, 59, and 60 of Lord Stevens' judgment. And it's also the bulk, in fact, actually all of the concurring judgment of Lord Burroughs. That's paragraphs 75 to 86. They are all on but-for causation and its relevance to private nuisance. And Lord Stevens was very clear that the purpose of the but-for test is to eliminate irrelevant causative factors. It's to be a clarifying lens to find out whether the breach of duty in a private nuisance claim caused the loss. And it's there to be used by the courts to do so. Now, in this case, because the encroachment occurred before 2004, and the duty arose in 2013, and there was a clear breach between 2013 and 2018, But the problem then is that the diminution of value occurred well before then, well before 2013 to 2018 and 2004. It was not caused by the defendant's breach during those years because it already happened. So therefore, the breach did not cause the encroachment of the knotweed into Mr. Davies's property. So what's good about this Supreme Court decision? Well, first of all, it's reaffirmed that but-for causation is of use for factual causation across the board. And I think that's very useful for all civil practitioners to know. I think it's also very good for us in the property line of work because it means but-for causation is definitely applicable in private nuisance, and that's applying to natural hazards and continuing nuisances alike. Coming to, and it's also, I think, it's also regularized the position between diminution of value claims and cost of treatment claims. They both have the same factual causation that is required for a successful claim. This was an issue that's been regularized by this, and I think that it's a point that's emphasized a lot by Lord Burroughs in his judgment, and I think that's very useful for the Supreme Court to clarify. And I think it's also very useful for us to know, and it's also clarified, that diminution of value is separate from the form of reasonable costs of abating a nuisance. So what did the Supreme Court not do in this case? Well, because it was mainly focused on causation, it did not talk really about, it did not get into any issues about what the nature of the nuisance of a Japanese knotweed case is. It sidestepped whether it can include this, what we would call the stigma factor of having Japanese knotweed on it, because the but-for causation meant it never got to that particular point. So it didn't really deal with that. It also didn't really talk about whether Japanese knotweed is a continuing nuisance and what can be claimed for that. Now, that's because in the original claim, the claimant never said the knotweed was a continuing nuisance. And this was a point that was brought up and the claimant's counsel had to admit to in the Supreme Court itself. So because of that, they couldn't claim anything for the damages for continuing to treat the property for Japanese knotweed. That was never going to be available to them. I suppose the lesson for that is, if you've got a Japanese knotweed case, always make sure to plead that it's a continuing nuisance, if it is so, in order to claim those damages that are potentially there. That's really what I've kind of had time I've been able to talk to you at the moment. If anyone has any questions, I'm very happy to answer them. Thank you, Sean. So the question is, do I think that bamboo is heading the same way as knotweed? I think so. I think the same facts still emerge that if you're going to have an infestation of bamboo or knotweed, you still need to prove that the breach of the duty causes the damage. I think the particular issue about knotweed and what the Supreme Court wasn't able to get into any detail because of the pleading is the continuing nuisance aspects of it, and because the knotweed just lies there and is a potential issue that comes down later down the line. So unfortunately, the Supreme Court wasn't able to clarify that. Okay, so if anyone has any questions for me later down the line, my email is asmall@kingschambers.com, and I'm very happy to talk about any issues that come out from this case. Thank you very much.